BlackRock estimates private markets could add 50 basis points a year to your retirement fund. The villain is a new Department of Labor rule. It shields your plan's fiduciary from lawsuits over that shift before it ever underperforms. That's 0.5 percentage point, and State Street has already made the shift. Your plan's fiduciary is the person legally responsible for choosing your investments. That shield exists before your money loses a single dollar. You don't vote on this. It happens automatically inside your plan before you ever notice. For 50 years, ERISA, the federal law governing retirement plans, has required one thing from your plan's fiduciary: prudence. They must act only in your interest, not the plan sponsors, not the asset managers. Courts used to judge that duty after the fact by comparing what a fiduciary picked against what a saver actually lost. The new rule creates a safe harbor, a checklist that, once followed, presumes the fiduciary acted prudently no matter the result. 6 factors make the list: performance, fees, liquidity, valuation, benchmark, and complexity. Follow the checklist, and the law now assumes you did your job. It does not ask whether your retirement fund actually grew. That is a meaningful shift. It moves the legal question from whether this actually protected your money to whether the right form got filled out first. This rule did not appear on its own. A 2025 executive order directed regulators to expand retirement savers' access to alternative assets. It aimed to clear away the legal obstacles that had kept those assets out of ordinary retirement plans for decades. The Department of Labor is now writing that order into permanent policy. Private equity and private credit funds do not trade on a public exchange. Nobody prices them minute by minute. The fund manager values its own holdings, on its own schedule, using its own models. That valuation gap matters more than it sounds. A stock's price is checked by millions of buyers and sellers every second. A private fund's price is checked by the fund itself. The complexity factor on that checklist asks something simple. Could an ordinary saver understand what they actually hold? Private credit funds are often built from loans most savers have never heard of, bundled into structures few people outside the fund can fully explain. There's a reason asset managers want this shift specifically. An index fund charges close to nothing, a fraction of a percent. A private equity or credit fund charges far more, in both management fees and a cut of the profits. Liquidity matters here too. That's how easily an investment turns back into cash. A stock can be sold the same day. A private fund often cannot be sold at all until the fund itself decides to let you out. That's a real risk for anyone close to retirement. If you need your money on a specific date, part of it may sit in something you can't sell on demand. The date and the money don't always line up. Most retirement plans automatically enroll new workers into one default fund. Workers can choose something else instead. Almost none of them ever do. The default is simply the path of least resistance. Meet Denise. She's 52 and works as an office manager. She has never chosen a fund in her 401k. She's been on the plan's default option since her first paycheck. That default option is a target date fund. It's the single fund that automatically adjusts its mix of investments as she gets closer to her retirement year. If Denise's plan just added a private allocation, her balance already includes it. Her statement doesn't say so. It still just shows a balance and a year. This isn't unique to Denise's plan. Statements across the industry report one balance and one target year, not the individual holdings sitting underneath it. No vote, no notice, no easy way to check the price. None of this is speculation. 3 separate sources document the same pattern: a federal rule, a Supreme Court case, and the law firms reading both. Start with the rule itself. On March 31st, 2026, the Department of Labor proposed fiduciary duties in selecting designated investment alternatives in the Federal Register. It lays out the exact 6-factor safe harbor. The proposal applies to every designated investment option in your plan, not just alternative assets. Comments were due by June 1st, 2026. If the rule is finalized as proposed, that 6-factor checklist becomes the actual legal standard fiduciaries can rely on nationwide. Plan sponsors are already being advised on how to use this safe harbor months before the rule is even final. The second proof comes from the courts, not the regulator. In Anderson versus Intel's Investment Policy Committee, retirement participants sued over hedge funds and private equity added to their target date fund. They argued it caused underperformance against cheaper index funds. The Ninth Circuit rejected the case in 2025 because the plaintiffs could not name a meaningful benchmark. A benchmark, in plain terms, is just a fair comparison. A similar fund, the court can measure the private one against. Without one, a judge has no way to say the fund actually did worse. The Supreme Court agreed to hear the case on January 16, 2026. The benchmark standard that sank that lawsuit is the same standard the new rule now writes into law. If the Supreme Court sides with the fiduciaries, that benchmark standard becomes settled law nationwide. That happens right as the new rule tries to write the same standard into regulation. The third proof point comes from the law firms advising fiduciaries directly. Gibson Dunn, Morgan Lewis, and Morrison Foerster each published analysis in March and April of 2026. All three trace the rule back to a 2025 executive order directing regulators to expand access to alternative assets in retirement plans. None of them dispute what the rule does. That's not something the rule says outright. It's the practical effect all three firms flagged for their fiduciary clients. It gives fiduciaries a legal shield before performance is even known. A federal rule, a Supreme Court case, and the law firms reading both the same way. Some fiduciary advocates argue the rule simply restores flexibility. Congress always intended ERISA to allow. The 6-factor checklist stays the same either way. None of them disagree about the direction. So here is what you actually know now. That 50 basis point estimate from BlackRock was never a guarantee. It was the argument built to justify a shift that's already happening. State Street's target retirement IndexPlus already holds 10% in Apollo-aligned alternatives. If that's your plan's default fund, that 10% is already inside your balance. Denise never opted into any of this. She never opted out of it either, because nobody asked. Most savers on a default fund never do. A private fund's price is not a market price. It's a number the fund itself decides to publish, on a schedule the fund itself sets. That distinction used to matter to a court. A rate card can be checked against a benchmark. A private valuation cannot. Not without naming one specific enough to survive dismissal. The Ninth Circuit already ruled that absence fatal once. The Supreme Court is deciding whether that ruling stands. A safe harbor was supposed to protect a prudent choice. Now it can protect a costly one too, as long as the paperwork behind it is filled out correctly. This is not one plan, one fund, or one lawsuit. It is the same 6-factor checklist every fiduciary in the country will be able to rely on once the rule is finalized. None of this required your vote. A rule proposed in 2026 formalizes what one executive order started in 2025. You are not most retirement savers anymore. You know the fund's name, the rule's number, and the case now in front of the Supreme Court. The next time your 401k statement lands, it will look the same as always. A balance, a date, a target year. It will not look like 10% of it sitting in something you cannot price yourself. But that is exactly what it is. An algorithm already sets your paycheck, shielded by a legal rule. The same kind of shield now protects the fund manager holding your retirement. Same playbook, a different account. We already traced this exact mechanism once, in a different industry, with a different number attached to it. Watch that one next.